I'm Teresa O'Mary. I'm the Director of the Blount County Office on Aging. And we have handouts and some brochures about the agency. And I did bring a few literature materials if you're interested and if it pertains to you. Help for agents under power of attorney. Help for court-appointed guardians of property and conservators. Help for surviving spouses. If you're a recent widow or widower, that's a great resource. And preventing financial elder abuse if you have a loved one that's in a nursing facility. All these documents come from the Consumer Financial Protection Bureau. Without further ado, let's welcome Mr. Matthew Harrelson. He's going to cover wills, trusts, powers of attorney, as well as other information. He is from the law firm of Kaiser and Black. Mr. Harrelson practices in estate, elder law planning, wills, trusts, and estate administration. His practice includes drafting wills and trusts and powers of attorney, health care directives, and other estate planning documents. He's very involved in our community locally. He serves on several nonprofit boards, and he also volunteers for presentations like today. Everyone, please welcome Matthew Harrelson.
Thanks much. If you've seen me before, normally I do take questions as we're going, but the format, I guess, is different, and I apologize. And since we're being recorded, I want to make it clear, I'm not your attorney. If I am your attorney outside this room, I'm not your attorney for the present moment. So I'm passing on information, but if you have a situation, there's nothing that can replace you sitting down and getting legal advice with your attorney one-to-one, okay? So I'm going to try to pass some information on, which just gives you a general idea of how things work and what you need to do to get prepared, and that's it. So I'm going to try to fly through this and get us out of here by noon, okay? So I'm going to go a little quick. I want to start by saying that when most people come to see me, they come to see me and they say, well, I'm here for a will. And that's great, and yes, we need a will. But often to me, that's the second thing we need to be worried about. The first thing we need to be worried about is actually incapacity. If you don't have any documents at all, and you pass away, and we'll talk about this in a few minutes, there is something that the law provides that's going to happen. And it may not be your favorite thing in the world, it may not be what your preferred plan would be, but there's something in place. A will always trumps what the statute says, but if you become incapacitated, however, and you don't have a power of attorney, that's a much bigger problem. What has to happen then is someone has to go to court and be appointed as your conservator and have to file accountings and report back to the court and get specific permission to deal with assets, anything really more than just routine bill paying. If they need to take withdrawals from an IRA that you're required to take, they're probably going to have to get court permission. If there's a CD that comes due and it's time to cash it out, they're probably going to have to get court permission. But even a bit worse is that there are all sorts of people that the statute says have standing, have priority to come be appointed as your conservator. That may not be the person that you choose. I have a client who recently has gotten to the point where she can't make her decisions anymore. And her older son stepped up and said, well, okay, I'm the eldest, so I guess it's time for me to start taking care of mom. Mom had been to see me a couple of years ago and prepared a power of attorney, which said, I want my middle son first, my youngest son second, and my oldest son third. And specifically told me that she didn't want him handling anything if there was anything she could do about it. So, even if it's a kid, one of your own, flesh and blood, you may not want that person, not because she didn't love him, but he's just not good with money. So that's extremely important, a power of attorney. I can't stress that enough. I won't go into much more of the details about powers of attorney today. I typically have a lot more questions about wills and probate and trusts and all that good stuff. So I'm going to kind of breeze past that and just say, please, if there's, we don't charge by the document, but if we did and one person came in and said, I can only afford one document, I'd say, okay, let's make it a power of attorney, okay? Extremely important. Powers of attorney also usually are of one of two varieties. They're either what we call general sometimes, or they are springing. Now, all powers of attorney are durable these days. We don't make powers of attorney, we don't draft powers of attorney that aren't durable. So when you hear durable power of attorney, yes, everything we draft is going to be durable. Durable means that it endures any incapacity that you might have, okay? This is based on old agency and principal law. If you appointed an agent and then you became incapacitated and lost the ability to then revoke that appointment, then when you did become incapacitated, they automatically revoke the appointment. Well, for a power of attorney, that's kind of why we signed it in the first place. If I become incapacitated, that's when I really need that power of attorney. So powers of attorney are always durable. General means when I sign it, you've got the authority right now if you're my attorney in fact. Springing means this doesn't take effect until some later date. Usually when a doctor declares me to be incapacitated or incompetent or otherwise unable to make my own decisions. The problem with that is if I'd say pretty much everybody in this room has a loved one or knows someone that has dementia. And that is not a light switch that one day flips off. It is a very gradual and progressive disease. In the early stages of dementia, I might need a little bit of help here and there. And as I go on, I might need a little more help and a little more help. I'm not to the point where a doctor is going to say, no, Matt's incompetent, Matt can't make any decisions, but I need help. And that's why we want that power of attorney to be valid the moment I sign it. Tell folks all the time, one of the best piece of advice I can give you, if you're concerned about that, is make sure you're appointing someone you trust. You need to be appointing someone you trust anyway. But if you're that concerned that you don't want this document to take effect until it's absolutely necessary and you're completely incapacitated, we might want to reconsider who you're appointing, okay? So I'm going to move on past powers of attorney and into kind of the typical estate planning. If you don't come up with a plan, the state does provide a plan for you. Now that's not always, again, as I said earlier, what you might prefer. It is your family. It doesn't mean that if you don't have a will, the state gets it all. The statute says that the estate would be split among the surviving spouse and children. Now, most of the married couples that come in to see me want to leave everything to each other first. That plan that the state has in the intestacy statute would not do that. It would say the kids get some of it right now. The spouse is left with at least a third, and the remainder is divided among the surviving children, or grandchildren as the case may be. So that's not, again, what most people want. That's not what most people prefer. Most people want it to go to the spouse and then to the children. So very important to come up with a plan so that you can control this yourself. Also, when we have heirs who are minors, whether it's a grandchild, we have or someone else, we have someone who's disabled, maybe they're on public benefits or they can't manage money, the state doesn't have anything built in to protect that. So if a 17 or 16 or a 5-year-old inherits something, then we've got a problem. Somebody's going to have to go be appointed a guardian. And again, we're in a court-supervised situation where the guardian has to get permission to spend money most of the time, where there have to be annual accountings filed. And at the age of 18, that child's going to get it. It doesn't matter if they're responsible or not. And I know years ago, maybe, 18-year-olds were prepared for that. These days, I don't think they are, especially the males. At 18, I don't think they need to be in charge of much more than a couple $100. So if you don't plan, none of this can be covered, and it's very important. So let's first talk about how assets pass at death. And there are several ways that assets might pass upon your death. First of all is joint ownership. So as a husband and wife, you own your house, and it's titled to the two of you, Matt Harrelson and wife Teresa Harrelson. That's what my deed says. In Tennessee, that's automatically a tenancy by the entirety is what we call it. Think of that as joint tenants with right of survivorship, okay? So if something happens to me, my wife automatically owns the house. She doesn't have to probate a will. She doesn't have to do anything. She owns the house. I can set up ownership that way with someone else if I want. My brother and I could own a piece of property and have that same right of survivorship so that if something happens to me, it's his. That controls, no matter what the will says, it doesn't matter. If I say I'm leaving that piece of property to Mickey Mouse, it doesn't matter. The surviving owner automatically owns it. Second is beneficiary designations. We say that on life insurance. So you take out a life insurance policy, you name your spouse, you name your child, you name whomever as the beneficiary. That's a contract you have with the life insurance company. And under the terms of that contract, they're going to pay the benefits to that beneficiary at your death. Doesn't matter what the will says, doesn't matter if you have a trust, that beneficiary designation controls. Same thing with PODs or TODs. POD is payable on death. We see that on bank accounts because they're just going to cash it out and write a check to the person designated in a POD. With an investment account, it's often called TOD. It's transfer on death because we're just going to transfer the account to them. We're not going to liquidate necessarily, we're going to transfer it. Same thing with those though. That's a contract you have with that company, with that bank, with Morgan Stanley, with whomever, to at your death, transfer or pay the proceeds of that account to the person that you designated. We also have some situations where someone might own a piece of property, but they give away the remainder interest. So I own the life estate, but at my death, it automatically passes to someone else. Again, this automatically happens. Doesn't matter what the will says or trust or anything else. That's going to take care of all those assets. I'll tell you, for most married couples, not all, most married couples, when one spouse dies, the surviving spouse often doesn't have to do anything. We've got wills that leave each other the estate in case there's something out there that we didn't realize wasn't titled jointly or didn't name the surviving spouse. But in a lot of cases, most cases, when one spouse dies, that surviving spouse isn't going to have to do anything. I've had several clients come in that have gotten into some sort of situation where they probated a spouse's estate. Somebody filed a claim. What am I going to do with this? And it turns out that really they shouldn't have even started probating the estate. They didn't have to because there were no assets in the estate. So if there's a couple pieces of advice you take from here today, besides getting a power of attorney, here's another one. If a spouse or any other loved one dies, sitting down, yes, you can open an estate by yourself. You don't have to have an attorney. But sitting down with an attorney for half an hour to see if you even have to do it in the first place is well worth it. Because those attorney fees are probably going to be less than even the filing fee when you go to probate. And we'd hate for you to have to pay that and start that process if it's not necessary. So, if there are assets, folks come in all the time and say, okay, help me avoid probate. We got to avoid probate. What is probate? Probate is simply the process of collecting the assets that are in the estate, that aren't passing by beneficiary designation or otherwise. Collecting all those assets, paying the valid debts, and distributing the balance to the appropriate people, whether that's people named in a power of attorney, in a will, or that's the heirs under the intestacy statute. That's it. It's a pretty quick process in Tennessee. It's a pretty cheap process in Tennessee. In a lot of places, we see folks moving from Michigan, Illinois, California. California's the worst. If you go through probate in California, but settle in and buckle in, it's going to be a long, bumpy ride. It's expensive. All these horror stories you hear from probate are in states like California. Stuff like, well, all the accounts were frozen for 6 months. We couldn't touch anything. They took fees of X%, and they took those fees every year, and then it went on for 2 or 3 years. All these stories are coming from other states other than Tennessee. I'll tell you, in Blount County, if you're a resident of Blount County, The probate filing fees, it doesn't matter if your estate is $10 or $10 million, the probate filing fees are $372. That's it. If you choose to use an attorney, most of us, I'd say the vast majority of us, charge hourly just like anything else. We don't take a percentage of the estate. We don't take a flat fee. Most of us that do this regularly, we charge hourly just like anything else. I have a lot of executors who want to do all the legwork. They want to be the ones to run to the bank and close the account. They want to be the ones to open the new estate account, pay the bills. I say more power to you. The more you can do, the better. All right? I've got plenty of work to do that I don't need to be charging you $300 an hour to write the utility bill each month. Okay? So I would much prefer that the executor go out there and do all that legwork. And I'm helping with the stuff that involves the court. Okay? Making sure that we get all the notices out and the things that the law requires as far as notice and other steps that need to be taken. I'm making sure those get done. The probate court's involvement is minimal in Tennessee, especially in Blount County and most of the surrounding counties. I'll say that Knox County is a little more difficult these days just because of the sheer volume over there. And the clerk and master who heads the probate clerk's office over there, they just had a new clerk and master come in. So they're also going through a transition. So Knox County, if you live over there, I just want to say, yes, it can take some time in Knox County. They're working on that. They're hoping to get that better. It's not always been that way. But here in Blount County, it's quick, it's cheap, it's easy, it's efficient. The court's involvement is minimal. We don't have to file accountings. We normally waive that in the will. We don't have to file an inventory. We normally waive that in the will. All these things, if we've got a will, we waive that stuff. If we have no will and all the heirs agree, we can waive all that stuff. So all the concerns about, well, everybody's going to know every bit of business about everything I had, we don't worry about that. That's not the case here in Tennessee. If folks are going to fight about it, then yes, we may get that stuff in the record and it may be public information. But whether we've got a will or a trust, we're in probate or not, if we're fighting and it comes to that, there's really nothing you can do to fix that. Okay? So let's talk about the estate. What is the estate? What are the taxes? Because folks come and say, well, if we set up a trust and just avoid probate, we don't have to pay any taxes. Well, that's not exactly right. The probate estate is small, the taxable estate is larger. The taxable estate is everything that you have an interest in at the moment that you pass away. So whether you have it in a revocable trust, whether you have it just in your name passing through a will, whether you have it in somebody's name as the beneficiary, it doesn't matter. It's all part of your taxable estate. So by avoiding probate, we're not getting out of paying taxes. But that's probably not going to be a big deal. For the vast majority of us, we're not going to have to worry about that. Back in 2001, we had these exemptions that were relatively low for death taxes. Less than $1 million. Then they started creeping up, and then they jumped up. And over the years, these exemptions have gone up and up and up. Tennessee remained unaffected until 2013, but in 2013, Tennessee finally changed things and caught up. So where are we now? As of 2016, when we woke up on January 1st, 2016, Tennessee no longer had a death tax. It's been repealed. As far as federal taxes go, the current exemption is almost $13 million per person. And that is portable. What that means is, if you are a married couple, you automatically get to double that, provided you file the appropriate return at the death of the first spouse. So, if you are a married couple and you have under $25 million, taxes aren't going to be an issue for you. Okay? Now, in a few years, those numbers are going to drop. Well, let me back up. As you can see, in 2021, the total number of taxable returns filed with the federal government, 2,584. That's of all the people that passed away in 2021. Back in 2000, 52,000 estates were taxable. So you can see what these rising numbers have done. Most of us aren't going to pay death taxes. The gift tax has also been repealed. So we get folks come in and say all the time, say, hey, we can give each of our kids $10,000 without any negative repercussions, right? Well, that's actually up to $17,000. Tennessee no longer has an estate tax. The federal government says you can give each person $17,000 per year without even having to file a gift tax return. If you go over that $17,000 per year to any specific person, what happens is that amount, that excess, comes off your unified credit. So we file a return. If we gave a gift of $18,000, we're $1,000 over, we're going to file our gift tax return, and that extra $1,000 comes off of that lifetime exemption that I just mentioned is $12.9 million. So for most of us, again, that's not going to be an issue. We can make those gifts. I do want to stress that this $17,000 is for tax purposes only. That is not for Medicaid purposes. And we have had several folks that have come to us and said, we're going to need to apply for Medicaid and do this and do that. And so we're going through, okay, have you made any gifts? Well, yeah, we made some gifts. We went ahead and started giving money away to kids, but we didn't give them more than the $17,000 or $15,000 or $10,000, whatever it was at the time, $10,000 a year. So we're good. No, you're not. Medicaid doesn't care what the tax code says. Medicaid says if you give anything away of value and you don't get equal value in return, you've just made a gift that we're going to penalize you for. So this is not Medicaid. This is just taxes. Medicaid planning is quite different. I'm not going to go into that today. Suffice it to say, that's another thing that you need to sit down individually with an attorney and talk about those issues and plan accordingly. So let's talk about trust versus wills. Again, back to probate. Do I want to set up a trust to avoid probate? And let me say that we do sometimes draft trusts. We have plenty of clients who have trusts instead of wills, revocable trusts. And there are several times when that's appropriate. It's not based on the size of the estate, because again, taxes, they don't care if it's in a trust or in the probate estate or whatever. It's not based on the size of the estate. It's based on other factors. Often trusts are used if we have, let's say, a blended family. I have my kids, you have yours. We're going to keep our assets separate so that mine passes to my kids, yours passes to your kids. Okay? And not every time we have a blended family do we do that. But it's an option available to us. A lot of times when folks come in and own real estate in multiple states, we consider a trust. Why? Because probate in that state might be a little more difficult than it is here. Or if we've got property in a couple different states, and we still own that piece of property back in Michigan, we're going to hang on to that forever, and we've got the beach house in Florida, and then our house here. Now we're talking about probate in 3 states. Okay, let's not deal with that, even if it's easy in 2 or 3 of those states. Let's think about a trust so we can avoid the process altogether. Whether you're using a trust or a will, they're all revocable, normally. Okay, we can prepare irrevocable trusts. We usually don't. Those are usually for a very specific purpose or for tax planning. But typically when we're talking about trusts for estate planning, it's revocable. So it doesn't matter if it's a will or a trust. You're going to be able to change it, amend it, do whatever you need to do with it over time. You're going to retain control of the assets, whether it's in a revocable trust or you've done a will. It's still your stuff, okay? No difference between wills or revocable trusts. It's still yours. However, when you use a trust, you've got to transfer assets and maintain assets in that trust. We have a lot of clients who come to us and they bring us a trust. Yeah, we've moved from wherever, and here's the trust that was prepared back in 2002. And yeah, we moved here in 2016. We just haven't been around to getting this thing updated, and things have changed. The kids are grown now. We have grandkids. So let's go through this and make all the changes we need to make. The first thing I ask those folks is, what's in this trust? You'd be surprised how many times I get a very blank stare when I ask that question. What's in the trust? Well, I don't know. I guess everything is. Well, let's look at the title to your house. Nope, it's in your name. When you came down here and opened a new account down here at a local bank, Did you open it in the name of the trust, or did you open it in your own name? Well, I opened it in my own name. How are your cars titled? Well, they're titled to us. All right. We don't have anything in this trust anymore. Why do we even want to bother with it? It's not doing us any good. With a trust, you'll get what's called a pour-over will that says at my death, whatever's not in my trust goes to my trust. But that's a will. That has to go through probate. We've now just created an extra step. We're going through probate, and then we've got to transfer it to this trust and then distribute it. We've created more work, okay? So that's not a good plan. If you're going to use a trust, we need to take advantage of that. We need to retitle all the assets, and when you open a new bank account, or you go from this bank to that bank because they got a better rate on a CD, you've got to keep that in mind. When you get a new car, and dealers don't like trying to transfer stuff to a trust, it's just, extra steps, extra work. So, but you've got to stay on top of it. If you don't want to do that, just use a will. As I said, going through probate doesn't make you subject to taxes, and avoiding probate doesn't automatically save you from taxes. Another reason I suggest to people to come in and see a lawyer before you just run down to the clerk and master's office and hand them a will and fill out that paperwork is this. If you go down to the clerk and master's office and say, here's the will, because we know their assets, so here's the will, they're going to fill out a petition to admit the will and appoint the named person as the executor or executrix of the estate, okay? We may not need to do that. That's typically what we call a full probate administration. We go through the full process of appointing an executor, publishing notice to creditors, waiting 4 months, all that good stuff. It may be a small estate. A small estate in Tennessee is an estate under $50,000. If it's a small estate, there's an affidavit we file. It's pretty simple. We file it, we get a certified copy, we go to the bank, and we close that one account that was in the estate with $30,000 in it. That's it. The clerk's office does have small estate forms, but they can't give you legal advice to tell you when you should or shouldn't be using it. Okay? Muniment of title. If all we've got is a piece of real estate, we just file the will. We don't open an estate, we don't appoint an executor. All we do is file a will, and that transfers title to the real property. We're done. All right? If we've got an ancillary probate issue, if we've got, we're going to have a probate in another state, or someone died elsewhere and we need to come here, again, something else the clerk can always help you with. And we've had folks show up that have opened ancillary probate here, and then now look at the mess, help me out of it, and they should have just done a muniment of title. So, again, if you're talking about, hey, somebody's passed away, I've got this will, what am I supposed to do with it? I can't stress enough, go spend half an hour with a lawyer. It may save you a lot more in the long run. We've got other alternatives to probate too, where we don't even have to involve the court. We don't even have to file a small estate affidavit. There's what's called the last paycheck statute in Tennessee, and it says that the last paycheck, if it's under $10,000, gets paid to certain people in this order, okay? What's great about that statute is it's called the last paycheck statute, but then it says, or anybody else that has no more than $10,000 in assets belonging to the decedent. We had a case a few years ago. It was a tragic case. A young parent and young child died. There was a life insurance policy worth $10,000. And the surviving spouse was just torn up. And I knew that if we had to do anything to go to court and deal with that, it was just one more thing, and she wasn't dealing well with it already. We called U.S. Able Life and said, hey, here's this statute. It's our last paycheck statute, but it includes anything valued at $10,000 or less. They wrote us a check. We were done. We didn't even have to go to court. We didn't have to file a small estate affidavit. There is a $15,000 limit with bank accounts. If there's a bank account with less than $15,000, again, there's a series of people that are entitled to be paid. Now, with the bank account statute, that is discretionary. The bank's not required to do it, and they can require you to fill out an affidavit that's very similar to the small estate affidavit that would get filed with the court. But we're still avoiding that. We're still avoiding paying the couple $100 in court costs to file the small estate affidavit. And we just fill out this little affidavit with the bank, and they'll pay over the proceeds. Typically, under any of these statutes, who's going to be entitled to those assets are going to be a funeral creditor. So if we owe the funeral home some money, we can go straight in and get them to cut a check to the funeral home. Funeral creditor, creditors for last illness. So sometimes if there are medical bills, we can just get those checks cut directly to the medical providers, not have to open an estate. After that, it's to the spouse, maybe the other heirs, maybe an unnamed or an executor named in an unprobated will. Depending on the statute, it's a little bit different. What I want you to walk away with is if we're just dealing with a few of these small assets, we don't have to go to probate. Again, go spend a couple minutes with an attorney. Let them get the full picture and decide what works best. Unclaimed property, tax refunds, we don't have to have an executor necessarily appointed. There are limits. If it's over a certain amount, we may have to have someone that proves that they have authority. But if it's a small amount, a family member may be able to claim those funds without taking any further steps. Vehicles, has anybody ever filled out the affidavit of heirship to transfer title to a vehicle? It's pretty easy. It's one page. You take it to the county clerk's office with the death certificate and the title. All the heirs sign off. We transfer title. We've not done anything with probate, just to transfer title to a vehicle. So, a lot of folks use beneficiary designations. I mentioned that kind of avoids the whole probate process. A lot of folks use beneficiary designations, and a lot of folks are encouraged to use beneficiary designations. We see folks that come in and I say, okay, who are the beneficiaries on this life insurance policy? Well, my spouse first and then the kids next. And these are minor kids we're talking about. So you've named these minor children as beneficiaries on a life insurance policy? Well, yeah, that's what our agent told us we ought to do. Well, okay, yes, they'll get it, but we're going to have a guardian appointed. The guardian's going to have to get court approval for any expenses, file those accountings. And at 18 years old, that child, no matter how responsible or irresponsible he or she might be, that's their money to spend as they wish. And if they need a new car, they're probably not getting a 2017 Toyota Camry, they're probably getting a brand new BMW. So let's be careful with beneficiary designations. Yes, they're handy and they make things easier. I've got a lot of clients who come see me. I had one the other day. She's late 70s, lost her husband, has one child, and that child has no children. And then she's got one sibling that's still living too, that's considerably younger. She has named her child as the beneficiary on everything that she has. And she's named her younger sibling as the alternate beneficiary on everything she has. There are no minors involved in this. There's no danger there. And that's okay. But if we've got a minor beneficiary, if we've got a disabled beneficiary, that might run into problems. Another thing we see a lot is, hey, I've got 3 kids. My oldest is the executor named under the will, so I'm going to name that executor as the beneficiary on everything. Well, that executor, they're receiving that not as executor of the estate. You've named that person, they're receiving that in their individual capacity. If that person wants to walk away with every bit of that money, they're legally entitled to do so. The other beneficiaries would have to prove that that beneficiary designation was meant as convenience rather than as a transfer of ownership. And the statute says that we presume when you name a beneficiary that you're intending to transfer ownership. So we've got to overcome a legal presumption. And how are we going to do that without hearsay? I don't know. It's very, very difficult. If you say, well, my son would never do that, he obviously is going to share it with his siblings. Yeah. But let's say that absolutely would happen, but your son gets in an accident and gets sued. Your son gets into a medical situation, has incredible medical debt. Well, guess what? Legally, that's his. His creditors may say, no, that's not to be shared with your siblings. Your parent named you as the beneficiary. That's your money. and you're responsible for these debts, and there goes the estate, okay? So beneficiary designations, while handy, can be a little bit dangerous. The TUTMA is the Tennessee Uniform Transfers to Minors Act. If you are naming beneficiaries on an account and they are minors, you can use the Uniform Transfers to Minors Act, name what we call as a custodian. Custodian is a little bit more limited than a trustee would be, but it names somebody to be responsible for that. So if you are going to name somebody who's a minor beneficiary on something, at least name a custodian under the TUTMA account. And most financial institutions, when you tell them that's what you want to do, they're going to know immediately what you're talking about and help you with that. Again, leaving by beneficiary designations to the son, who we say is going to do everything. If his wife has different ideas, or the daughter's husband has different ideas, or whatever, we may have problems. Typically, inherited assets are protected. They're not marital property unless we make them joint. So if I inherit something, it's my separate property until I put that in a joint account with my wife. But if I put that in a joint account with my wife, that has become a marital asset. And if then we're going through a divorce, we may have issues. Beneficiary designations can't protect against any of that. Did I just skip one? Nope. Okay. Beneficiary designations can also create an unequal distribution. This is a story I tell a lot. If you've heard me talk before, this is the story you've heard a few times when I've talked about beneficiary designations. Had a client that sold her home, went into a facility, started an independent, then assisted living. And when she sold her home, she took roughly $300,000. She put it in 3 CDs. She had 3 kids. She named one child as the beneficiary on each of these CDs. And she maintained about $30,000 in her checking account, but then when she went from independent to assisted living, she was paying out a little bit more each month. Now she's got to, at some point, dip into one of those CDs. So she liquidates a CD, puts that in her checking account. She goes a little bit more, we need to liquidate the second CD. We liquidate that CD. When she passed away, she had about $30,000 in her checking account, which was part of the estate to be divided equally among the 3. But we had some medical bills, we had the funeral to pay for, a few other odds and ends. It was a $10,000 funeral bill. Medical bills were a couple grand maybe. So at the end of the day, we had about $10,000 to be split between the 3. The remaining CD paid to one of the kids, and guess what? He took it. He wasn't sharing with his siblings. Nope, this is the one Mom wanted me to have. I'm keeping it. So that's got to be very careful. You know, I would have told her, well, if you're absolutely insistent on using beneficiary designations, name all 3 of them as equal beneficiaries on all 3 of those CDs. But hey, let's back up and maybe come up with a better plan anyway. A lot of folks that we see have beneficiaries named on everything, and they've got their house and car, and they pass away, and we've got this house and car that are part of the estate. We sell the car, we get a little bit of money, but from as far as the house goes, hey, we're paying utilities each month, we're paying insurance, we may have a property tax bill that comes due, we may need to replace some floors before we put this house on the market, and we don't have any money in the estate because everything just went by beneficiary designation. And again, if the kids aren't getting along and they don't all agree to chip back in their equal share, somebody's going to be shouldering that burden by themselves. So it's important sometimes, often, especially if we have real estate, to have some capital, some operating expenses in the estate to work with. If we take it all out, then we may have an executor that's got a bunch of stuff to do and doesn't have the money to do the job. A lot of folks, going back to powers of attorney for a minute, a lot of folks say, well, I don't need a power of attorney because I put my son on all my bank accounts. So he can write all the checks that he needs to write. He'll take care of everything. Okay, that's great. But when he calls the insurance company to talk about a claim, or when he calls the cell phone company to suspend service because you're not using your cell phone when you're in the hospital, they're not talking to him. It doesn't matter if he's on the bank account. They don't care about that. If he doesn't have power of attorney or some other legal authority, they're not going to talk to him. So we've got a lot of folks that think that just solves everything, and it really doesn't. I will say that again, beneficiary designations can be handy, but how many times, I can't tell you how many times, we've had a estate plan that somebody came in and worked hard to prepare. We have a good will or a good trust that's going to take care of everything. And then when they pass away, we've got beneficiary designations on everything that bypasses all of that. Met with a family fairly recently. The daughter is not great with money. So mom set up a trust to protect her, to manage it for her. The daughter, shortly after mom passed, was already doing stuff she shouldn't have been doing in anticipation of an inheritance. And guess what? With all those beneficiary designations, and no matter how many times I told mom, you need to go check that, go update your beneficiary designations, name the estate as the beneficiary. She didn't do it, and the daughter's got it. And so there's nothing we can do to protect it. Litigation and estate disputes. I want to talk a little bit about contesting a will. Contesting a will is not an easy thing to do. I'll say contesting a will, but contesting a trust is pretty much the same thing. If you have 3 children and one of them is estranged and you leave everything to the other 2, that 3rd child doesn't get to contest just because they're a child. They can't come say, wait, I'm a child, I deserve some. No, you don't. To contest a will or a trust, you have to prove that either there's some defect in the documents on their face, or that the person, at the time they executed the document, didn't have the required mental capacity to do so, or that the person, at the time they executed the document, was subject to some sort of undue influence from someone. So that's the classic case of one of the 3 kids takes mom to the lawyer, says, well, mom, just leave everything to me. And she agrees to because she relies on this child. He takes care of her, takes her to the doctor, he gets her groceries. She's completely dependent, and she's scared that if she says no, he's going to quit doing that for her. That's kind of the classic undue influence case. So you've got to show, again, undue influence or lack of capacity in order to successfully contest a will or a trust. Not only that, but to start a will contest, the probate court has to actually give you permission. It's one of the few lawsuits that you have to get permission to file it to begin with. You can't just go file a will contest. You have to go to the court and show that you have standing and a good enough reason to contest that will, and the probate court will make that decision as to whether you get to proceed. So people get concerned about challenges to a will or a trust, and I tell folks it's very hard. One of the best things you can do is have a lawyer prepare and witness the execution of those documents. That's huge. We talk about LegalZoom and Rocket Lawyer and all these others that have these online packages that you can go in and plug in all the information. I see problems with those, okay? I see some that are okay though. But we've had problems such as the will was witnessed by 2 people who are also beneficiaries under the will. That doesn't work, and that means they actually don't get anything. We've had problems where someone claims undue influence, and the people that witnessed it, when they get on the stand and they're asked to define what the legal requirement to have that capacity is, they have no idea. They couldn't tell you. Don't know. She seemed okay to me, so I signed it. Some of them may say, I don't even know. I didn't pay attention to that. I watched her sign it. That's all I'm witnessing was her signature. That's not going to help. If you have a lawyer that's familiar with this, that prepares and witnesses the execution, that is the best protection you can have for a will contest. As lawyers, we know what the legal standard for capacity is. We can go in, we testify to the court, and I can tell you that it is extremely difficult to challenge a will that's been prepared and executed by a lawyer who's familiar with estate planning. Okay? So, best protection you can buy yourself. Blended families, of course, we see a lot of that. If you have a blended family, let's get a good plan in place. We might trust the stepchildren both ways. I might trust my stepchildren, my wife trusts her stepchildren, but when one of us is gone and my kids don't step up to help with her and there's a little bit of a rift, what's going to happen? The estate may be left to the others, and mine get cut out. So it's important with a blended family, and that's where we're seeing a lot of litigation these days is with blended families. Is one side feels like they were shunned, they were excluded, they were marginalized, whatever. Again, trust packages, the online legal services, we see a lot of these. Again, execution is a key. We had a case. It settled rather quickly out of court. It was $1 million plus estate, and the way that the witnesses signed the will was wrong, and it just automatically invalidates the will. And the will left everything to a friend who had, admittedly, in the last 5 years of this woman's life, stepped up and done a lot. And you ask me, I can't tell you that that's not what she wanted. It very well may be what she wanted. And she went and saw a lawyer. That lawyer didn't do a lot of estate planning. And that lawyer messed the execution of that will up. And guess what? That was a, hey, we're out here on summary judgment. We don't call a lot of stuff. We never give guarantees to outcomes, but a lot of stuff we'll say, that's pretty much a slam dunk. That was kind of a slam dunk for the family that wanted to contest it. So, trying to leave a little bit of time for questions and get everybody out.